the matter of Lakatamia Shipping Co Limited and others and sue.
Good morning.
Good morning, my lady.
We have, as you appreciate, been rather inundated with paper of late. And so, just to make our position clear, we'd like first to hear very briefly the application in relation to amendment and the objections to it. Nevertheless, we want to just hear a thumbnail sketch of that, but we're not going to make that decision here and now. It will be reserved over, nevertheless. And then, just so that you're aware, we want to know, please, and that's putting it rather bluntly and straightforwardly, we want to know what the position actually is in relation to everything which has happened or hasn't happened since the permission to appeal was given, and what each of you say is the effect of those further events upon the appeal. So those are the two things that we think are important to get straight, first of all. Thank you.
Thank you, my lady. I appear with Mr. Turner, who sits behind me, and we've been assisted, I should say, by Mr. Forsyth, who's a pupil in my chambers, whose name appears at the end of the skeleton argument that's caused so much consternation since it was served on Friday last. And I'm conscious that my retainer last week led to my taking the view, rightly or wrongly, it appears my learned friends take a rather dim view of my behaviour, that this court would be assisted by a fresh skeleton argument, which was produced at extreme pace. And if it contains any infelicities, my lady, I take responsibility completely for those infelicities. I only beg the court's indulgence to say that on Monday evening, when I was delivering a lecture in the Middle Temple, I wasn't aware that by Friday I would be delivering a skeleton argument to my learned friend and receiving brickbats back for having served that skeleton argument. And it was produced at pace. If it hasn't assisted this court, I can only apologise. The view I took was that the skeleton arguments that the court had previously received, and I put the matter delicately, were not necessarily skeleton arguments that would assist this court in coming to a proper answer to the issues that were raised on the appeal. My lady, yes, sorry.
Yeah, well, Mr. Grant, I think we'd all like the heat taken out of this on both sides.
Yes.
And it doesn't help us to have counsel rowing.
No, quite.
I don't think any of us want to say any more about that.
No, well, I respectfully agree,
I mean, we need to try and use our time wisely to try and produce whatever a resolution or whatever is truly at issue between the parties.
My lord, that I respectfully, if I may say, concur with that.
I entirely agree with Sir Nicholas Patten, and I was about to say I'm not concerned in any way with what may have been going on between you. You don't need to apologise in any way to us. All we need to know is the basis for the amendments and a short explanation of why we should accept them, and short, because we've read the written submissions, a short explanation of why that's not appropriate. That's all.
Well, my lord, let me go straight to that. I'm afraid a yet further piece of paper may have made its way to the court yesterday afternoon, which is in the shape of my solicitor, Mr. Crichton's witness statement, which is a very short document, which effectively, we read my learned friend's skeleton argument of yesterday, and one of the points that was taken is there's no explanation given, etc., etc., and what Mr. Crichton has endeavoured to do there, in, I hope, an entirely neutral and non-contentious way, is to say his instruction, and ergo my instruction, was a function purely of a third party who has come forward to put Mr. Crichton and Ashford's in funds. Those funds were produced on Thursday morning, as I understand it. Obviously, I'm not privy to that. I'm simply receiving instructions from Mr. Crichton, and the court has had the evidence. it's fair to say that I started work earlier, speculatively, and if those funds hadn't come through, then, well, c'est la vie. But we took the view that, on Counsel's side, that we were in a rock and a hard place. We knew that there was a hearing on Wednesday or Thursday, so we started work earlier in the week, speculatively. The funds came in on Thursday. Mr Crichton came on the record, and we delivered our skeleton on Friday afternoon. Melly, that, in terms of the complaint made by my learned friends, which is very late, and of course I can't in any way say anything against that. Of course it's late. Of course it's late. We've just done our best in those very difficult circumstances we found ourselves in. If we've done wrong, I again apologise. I won't say that anymore. I won't apologise again. I've given the apology. And all I can say is that Mr Sue is, he's not a stranger to these courts, and certainly not a stranger to the commercial court judges. And he was last week facing a hearing which took place, I believe, on Tuesday and Wednesday. And there's no secret in this. He was sentenced to 24 months, the absolute maximum available to Sir Michael Burton for his third series of contempts of court on Wednesday. And the funding of the third party was, as Mr Crichton says in his witness statement, as he understands it, out with the control and influence of Mr Sue. It may be said, and all I can say is what Mr Crichton says in his evidence. I can say no more than that it may be said that Mr Sue has somehow engineered a late delivery of funds in some way. I don't know. But there is a suggestion that Mr Sue has sought to disrupt this court's proceedings via my late instruction. All I can say is that I am no party to that. I've just simply done my best. My lord, my lady, my learned friends have put in a skeleton, and I don't in any way diminish the fact that my learned friends have been put to trouble and effort by events of last week. I don't diminish that at all, and they have produced in double quick time, I should say, a skeleton which came in yesterday, and it's a I may say, a very well-crafted skeleton argument, and I will have cause to make submissions upon it. But in that skeleton argument, they raise a number of objections to the application, and it may assist if I were to invite you, the court, to open up my learned friend's skeleton argument, paragraph 7, where they set out a number of points, and I will deal with those hopefully as quickly as I can. This is, of course, an objection not only to the new skeleton, but also to the new grounds. Yes. So I'll deal with those compendiously. Can I just say one thing about the skeleton argument? It's absolutely right to say that in the skeleton as it was produced and served on Friday, we said it was an additional skeleton. And that was advised in this sense, that in our hurry of last week, we were nervous as counsel in the shape of, with 72 hours or whatever it was, to get from 0 to 60. Not to sort of jettison anything. We were concerned not to say categorically substitute at that moment, because there might be something within the earlier skeletons which we'd missed or whatever, and I didn't want to have some technical point taken against me. In the light of mature reflection, which I've had more opportunity to engage in, subsequent to Friday of last week, it struck me that, in fact, we had done better than we thought, and that, in fact, the skeleton we'd produced probably is a replacement. My lady's right. I don't think there's anything within the previous skeletons, with respect to Mr Underwood, Queen's Counsel, that your ladyships and my lord needs to trouble themselves with. I hope my new skeleton, insofar as you admit it at all, I quite accept that's a provisional question, provides the submissions which I hope will do justice to Mr Sue's appeal. That's just something I wanted to clear up, and I quite understand why my learned friends made that point. I quite understand that, but I wanted to make that clear. Paragraph 7.1, I've probably already dealt with the first ground of objection, a favoured tactic to disrupt hearings. That may be right. I just don't know. I'm not an absolute diligent student of the entirety of the. I mean, there must have been dozens of hearings in this case over the years, and I can't pretend to be able to provide a a rebuttal of that. All I can say
well,
is...
Mr Justice Waksman's likely to be right, isn't he? He will be well familiar with this, and if you look to see what he said, as recorded in 7.6, there is a history
My lady,
and
yes.
a pattern.
I'm certainly not going behind that. Absolutely not. All I want to say is that I hope I'm not in any way party to it. I may be an unwilling tool, a useful idiot, I don't know, I might be. But I'm not a willing or intentional party to that. And the decision to put in a new skeleton, I should say, as I hope the court will understand, was not Mr Sue telling me...
To waste time and energy? No. It was your conclusion about the best thing to do.
Yes, so that's all I wanted to say about...
But Mr Grant, with respect, I mean, we're not really just talking about you putting in an extra skeleton, are we? Because, I mean, you're putting in an extra skeleton because you're asking for permission to amend the grounds of appeal.
Well, can I come straight to that?
The two are indissoluble.
No. Well, I see that, my lord. But I was going to come straight to that because, my lord, I don't accept that the new grounds actually go really any further than the old grounds.
Well, just a minute. Sorry. I mean, if you're right about that, then in a sense it diminishes the difficulties about the skeleton, because if all your skeleton is, I mean, it's tiresome to have, from a sort of case management point of view, to have extra pieces of paper that, to some extent, overlap with others and say the same thing but at greater length. But the truth of the matter is that that's not so difficult to deal with from an advocate's point of view, as opposed to if what one is actually having to do is to deal with new grounds of appeal.
My lord, I don't accept that the new grounds of appeal go beyond that which was already in issue. Yeah. What I do immediately concede, and I'm bound to concede, is that I have sought to reformulate them, and I've sought to do so actually to assist this court, because it struck me that there were bound up within the existing grounds a number of strands of thinking and reasoning, which, if they were extracted and repackaged, if I can use that phrase, would assist not only my learned friends, but also this court. Can I go straight to the old grounds and the new ones, so to speak? The old grounds are to be found in the appeal bundle, which is a mercifully short bundle, now dwarfed by, as your court doesn't need to be reminded, a lot of authorities.
Is that what we've got as the core bundle?
Yeah, that's it. The core bundle is the bundle, albeit there is an exhibit to Mr Gardner's 28th witness statement, which is a separate document. A separate bundle has been put in yesterday at the request of my learned friends, quite understandably. My lords, my ladies and my lord have the new grounds, or the old grounds, at page 14 of the core bundle, tab 1. And you'll see there are two grounds. And ground 1 is the ground relating to Article 8. And ground 2 is the ground which is, in fact, on analysis, engages, possibly unhelpfully, two separate strands of thought, which is we've sought to extract, which is one, the point of the bankruptcy order, and that goes away now because that's been set aside.
Well, I was going to say, we're not worried about that.
Absolutely right, my lord. But at the end of ground 2, and in concluding that the continuation of that order didn't infringe the applicant's Article 8 rights, and I'm very unkeen to show your lordship, my ladies, the earlier skeleton arguments for reasons I've already articulated, but Mr Underwood, possibly a little unhelpfully, I'd say no more than that, binds up the bankruptcy question and the proportionality question together. And we've sought to decouple, not necessarily because my learned friend succeeded before Mrs Justice Bacon a week and a half ago in respect of the bankruptcy issue. But
she's annulled the bankruptcy.
She has, my lord, yes. Yeah. That leaves, in our respectful submission, the question of the infringement of the Article 8 rights. Now, let me go, your Lordship and my ladies have the grounds as they were before Lord Justice Mayles. The new grounds are contained within the application by way of a sort of draft order. And I don't know if that's convenient just to turn to those now. So the court can see precisely what I'm trying to say. And we have that, if the court has it. There's a draft order attached to the application notice. And on page 2, we see grounds 2 and ground 3 in italics. And ground 2 is the passage of time point.
Yeah.
And I should immediately say this, that if the court were to turn to Lord Justice Mayles' order of the 26th of March, page 15 of the core bundle, it will be seen that in his reason 1, he deals with the question of illegality, which is now, we've tried to turn into ground 3.
Sorry, where is the order?
Page 15, tab 2.
Oh yes, of the core bundle.
That's it, thanks. And Lord Justice Mayles deals with the question of whether a court order requiring, I'm not trying to be contentious about this, there's obviously arguments either way, requiring a person to break the criminal law of the country by making an order as has been made is an unlawful interference with that person's Article 8 rights. But he then goes on to say at the end of reason 1, as the court can read, it may be that an order which was initially proportionate could cease to be so if the restraint continued for a lengthy period. Now, it might well be said that the question of proportionality of a restraint, and in blunt terms, it's simply this, reducing it to its very quintessence, that an order which effectively prevents a foreign national from leaving the country, which has all sorts of ancillary consequences, and which persists for a year or 18 months, or 2 years, depending on where one starts. And I accept there are arguments about where one takes the start point. I'm not going to go into those now. That is it, essentially. That's what has happened. An order has been made which has required Mr. Sue to remain in this country, subject to various disabilities, for a considerable period of time, whether that time is pitched at X days or Y days. Now, there are 2 ways of analysing that.
But why does, I'm sorry to butt in, but it just helps to sort of for my note, but why does the fact that the passport order could, on one view of matters, also put you in difficulties with your immigration status, add to the Article 8 complaint? That's what I don't understand. I mean, Article 8 is concerned with an interference with your private life. I mean, the passport order itself does that.
Yes, quite right.
But the fact that as an adjunct to that, you may also find yourself in difficulties with the Home Office because your visa is expired. How does that, one way or another, add to you the objection on Article 8 grounds?
My Lord, I'll tell you immediately why it does, in my respectful submission. For this reason, that simply the complaint is not simply this, that by making an order pursuant to Section 37, the commercial court has placed Mr. Sue in breach of the criminal law. That is certainly a complaint which is made and which has persisted in this court. But further, a person who is an overstayer, has remained in the country without a valid visa after 90 days, is not simply in breach of the criminal law, simpliciter. That person is also, as a consequence, subject to a variety of disabilities. And in the Immigration Act, for instance, it says that an illegal overstayer cannot lawfully work.
That's called the hostile environment.
Absolutely right, my lady.
Can he work anywhere? What sort of visa did he have?
He had no visa because under the arrangements between Taiwan, from where he came, on that fateful day in January 2019. He arrived without any visa at all from Taiwan. And I understand he's a dual national, Japan and Taiwan. He arrives at Heathrow.
Does he not need a visa?
No, what happens is that at the airport, he is stamped, or it may not have happened because he was apprehended.
Yeah.
I don't know. But what would normally happen is you're stamped, because you're arriving from Taiwan as a Taiwanese or Japanese national, there's a stamp placed in your passport which says you have 90 days. That's an automatic entitlement. But after that 90-day period has expired, unless you have extended your visa entitlement via bringing yourself within a variety of possible categories, then you are in breach of Section 24 of the Immigration Act, and you are a criminal. You're criminalised, I should say. But the consequence of that is not simply to criminalise you, but as my lady said, it has knock-on domino consequences. You cannot work.
Well, can you work within the 90 days?
That I can't assist your lordship.
I wouldn't have thought you could.
But I don't think it matters.
Well, it does matter, because otherwise there's been no material change in his status.
Well, my lord, it's a matter for argument, and your lordship will either...
Well, I'm asking you the question.
Well, your lordship will either agree with this or disagree with this.
Well, I'm not in a position to do that. I just want to know what your position is. Are you saying that within the 90 days permitted under his entry visa, or whatever you want to call it, he was able to work?
I can't give your lordship a definitive answer to that, but I suspect the answer is no.
Right.
That's
what I would have thought.
But no, but my lord, the matter goes further than that, if I may suggest with respect. Mr. Su did not come here with a view to working. The evidence is he came here with a view to changing planes and going to Germany, where he had some form of business meeting about which I know nothing. So he was here in transit. He is then detained, subject to Mr. Justice Bryan's former order of 2018.
Well, I understand that, but it's got nothing to do with his ability to work.
No, can I... Well, let me just make the submission, my lord, and either it finds favour or doesn't. He doesn't come here to work. He came here in transit. He's then subject to the order. He's retained here. After 90 days, he's criminalised. And he's then unable... He doesn't want to be here, but if he's forced to be here, then he would at least like, I suspect, some form of residual quality of life. And residual quality of life, I respectfully suggest, would involve, for instance, if he has to be here, then the ability to work. And he talks about this in his witness statement. But it doesn't go...
A better example for you is access to the NHS.
That was going to be my next example.
That may be a safer example.
It's just a suite of consequences which the court will consider. He's unable to access the NHS, and again, he puts in evidence to that effect. He is unable to enter into a tenancy agreement.
Has he applied for an extension of his leave to remain?
He hasn't, because...
Well, why hasn't he?
For this reason, my lord, because the prospects of obtaining that extension to remain are nil. I know there's a contentious issue between the parties.
Well, why can't he just simply apply and say, look, I'm here I don't want to be here, but the commercial court has ordered me to stay here, and of course now he would have to say he's in prison because he's been committed. I'm not here voluntarily, and in those circumstances, please extend my leave to remain.
Well, let me make the submission. I think it's accepted on both sides that the Home Secretary has a residual and exceptional discretion, i.e. a discretion which will only be exercised exceptionally. And that there are materials before the court which show that, and I think my learned friends have said that in their second skeleton argument. The Home Secretary can exceptionally give a person leave to remain, even if they don't fall within any of the categories. And he doesn't. We've scoured the categories. We can't see any single category he could bring himself within. And we respectfully suggest to this court, it's a matter for the court, of course, that Mr. Su going before the Home Secretary and saying, I've now been committed 3 times for various contempts of court. I'm now entering my who knows what month of detention. I mean, he's already... But can you, because Mr Justice Waksman has made this order, would you give me leave to remain, which will have all the consequences that I can now work, I can now access the NHS, I can enter into tenancy agreements. I would respectfully suggest, and I make the submission, it's for your lordship and my ladies to consider it, that the notion that the Home Secretary would say, No, it's a hard case, Mr. Sue. We're very sympathetic to your position. We will give you exceptional leave to remain so that you can work, you can enter into tenancy agreements, you can access the NHS and all the panoply of benefits that would flow from that. We will. I would respectfully suggest the notion that the Home Secretary would exercise her discretion in favour of this man
All right.
is beyond argument in my favour. I make the submission, and that's
All right. Well, it's my fault. I've taken you by trying to sort of drill into what's in the first ground of appeal. But I think you were at the point of explaining to us why you wanted to widen.
Well, so I'm back at ground 2.
In relation to ground 2, you told us that it is focused on passage of time, and if we look at Lord Justice Mayer's permission to appeal, we'll find at the end of his first reason the reference to something which is initially proportionate might cease to be.
My lady
and
is right.
therefore you say that is teasing that out, and that's why ground 2 is as it is.
And my lady, my lady has it entirely.
So unless there's anything else on that, shall we move on to your proposed ground 3?
My lady, so be it. Ground 3 really is the same as ground 1, or an aspect of ground 1, which we've sought to tease out into a separate ground in order to assist in, hopefully, the reasoning process and the argument process. Now, it was always there on the face of the grounds and on the face of Mr. Underwood's skeleton argument, the criminalisation point. Now, we have, as equity lawyers, perhaps my lord might raise an eyebrow at that statement, we've looked in our books and we've seen the famous dictum of Lord Evershed in Pride of Derby, which will be Hornbook law to this court, which says in terms that no court exercising its Section 37 jurisdiction, or the prior equitable jurisdiction which Section 37 seeks to put into statute, will make an order which requires a person to criminalise him or herself. And we've looked at Professor Spry's book, and we've put that into the bundle as well, which
so, Mr. Grant, you say that is an aspect of ground 1, and
Absolutely.
it's just teased out, and that's it.
My lady is exactly right.
And so
Now,
you say there's nothing new in any of this, nothing takes anybody by surprise, it's all meant to assist the court, so let's move on, is what you say.
Exactly right, and I should say I look to my right, and we have intellectual firepower which fills me with trepidation on the other side, who have been able, I accept they've no doubt burnt their own midnight oil, and I accept that and have done a very good job. And there's no prejudice to my learned friends and my learned friend's client in the way we've sought to do it. I accept there may have been
But that's, I mean, in a way, 3 isn't any more than a sort of slightly different way of putting 1, is it?
Quite.
I mean, it's concentrating on the Section 37 jurisdiction point rather than on Article 8, but it's
Quite.
essentially the same point.
My lord has it.
Yeah.
There are, I'm conscious not to detain the court, but there are, paragraph 7 of my learned friend's supplemental skeleton argument, a variety of points made against me.
Okay, but while we're on that, I mean, I don't know how you want to deal with this, Mr. Grant, but speaking of myself, I mean, I think the real problem, or one of the problems you may have, is that this appeal is concerned with Mr. Justice Waksman's order, which was made back in January.
Yes.
Well, I mean, a lot of water's flowed under the bridge since then, including, not least, the most recent order of Mr. Justice Burton, or Sir Michael Burton, as he knows, which has put your client back in Pentonville.
Quite right, my lord, and I was going to address that point.
And has time limited the Waksman order, the passport order. I mean, whereas I hadn't entirely appreciated this, but it's been made clear to me that although the original passport order was geared to the second examination hearing, Part 71 one hearing. It's not now. It's limited in point of time, I think, to the end of July, isn't it?
My lord, absolutely right. I have a.
And you're not going to be out. I don't mean you personally, of course. But you're not going to be out of Pentonville.
I don't know, my lord. Depends on what the court orders.
Before the end of July, whatever early release is operated, so that the passport order, unless something else is done, will expire long before you're in the position to exercise any rights that you would have, whether under Article 8 or otherwise.
My lord, can I immediately address that? And I believe it also encompasses what my lady asked me to address initially, and your lordship's quite right to raise it, if I may respectfully suggest. There are, and it kind of is bundled up with a point made by my learned friends in their supplemental schedule, which is this is an academic appeal.
With force, yes.
With force. Well, I disagree respectfully, and I'm going to try and persuade your lordship, your ladyships, why it isn't academic. There are three essential reasons why it is not academic. The first is that, I am told that Mr. Tier, who is the solicitor acting on the committal, has put in a notice of appeal with grounds. I've not seen them.
They've been sent to us.
Well, your ladyship has the advantage.
I mean, on any view, whatever success there may be, nobody's going to be able to, realistically to suggest that any reduction in sentence on appeal will bring the sentence down to a period which would be shorter than the period of time for a second CPR 71 examination.
Well, I mean, the CPR, can I just say this? When Mr Justice Waksman made his original order in January 2020, his first order rather than his second order, and we've tried to tease this out in our skeleton, it seems to us, reading the order he made, and we can look at it if necessary, he anticipated that the second means examination and the passport order to which it was ancillary would come on within a matter of weeks. And hence, for instance, he required the parties to give their dates to avoid by the 4th of January, which was just 4th of February rather, which was just a matter of days after the order was made. And it was duly listed before Mr Justice Butcher, or before at least a commercial court judge, at the end of March, so within 2 months. And your ladyship will have seen that there's been a series of orders and events post the first Waksman order, which I'll have to come back to. I'm not going to deal with those precisely now. So it was envisaged that Part 71 examination would come on post-haste by Mr Justice Waksman. So it appears from the shape of his order. Now, we're now here in July 2021. 18 months have gone by, and we still haven't got a Part 71 application even listed. So when my lady says, well, whatever happens on the appeal, the Part 71 cross-examination will necessarily come on before Mr Sue comes out of prison, even on the best-case scenario in the Court of Appeal, I respectfully say, well, not entirely sure that's right.
Well, if I may run with my Lord Sir Nicholas Patten's questions, there are three developments since permission to appeal was granted on the 26th of March.
Yes.
First is Sir Michael Burton's order of the 15th of April.
Absolutely.
Which means the passport order expires in 2 weeks. The second is, on the 7th of July, your client is sent to prison for 2 years.
Yes.
The third is, the parties, as I understand it, or certainly the respondent, is working on the basis of a hearing date, if not this month, then September of this year. Now, I would be interested to hear, in that context, what possible purpose this appeal serves.
Right. My learned friend is right to say my learned friend before Sir Michael last week, and I've looked at the transcript, said, we're trying to get this on. Mm-hmm. Now, I'm sure he said that with absolute good faith, but the history of these proceedings since January 2020 shows that within 18 months it hasn't come on.
Yeah, but that was because of the disclosure exercise.
That disclosure exercise took place in the search order took place in June 2020,
yes.
And we're a year away. We're still a year away, and so. Who knows?
Mr Justice Butcher adjourned the hearing.
He did.
Well, you're not appealing that.
My lord, I'm not. I haven't been. Not least because I was instructed 18 months after it. I'm afraid.
Well, I know, but I'm only talking about, when I say you, I'm talking about your client. I mean, your client hasn't challenged the adjournment of that application.
Well, he consented to it.
Exactly.
To be absolutely clear, I don't want to be. He consented to it, but my lord, he consented to it as a man who was then in his 11th month of imprisonment at Pentonville.
So what? I mean, he consented to it.
He was unrepresented.
Well, are you saying he shouldn't have consented?
I'm not saying one way or the other. I'm merely saying one needs to weigh the consent.
Well, has he gone back to the commercial court and said, I was languishing in prison, I was unrepresented, I know I consented to it, but that isn't any longer my position?
The adjournment
has he done that?
The adjournment happened. There's no, one can't go back in time. But let me address my lady's point, if I may.
I think the answer's no.
Let's assume that my learned friend's hopes and expectations are met, and it comes on in September 2021. This cross-examination. Now, experience shows, and I, for rightly or wrongly, have some experience of how claimants in my learned friend's shoes act in these cases. I'm not saying with impropriety. The notion or that cross-examination in September, when he's brought out of Pentonville, brought down to the Rolls building, will be the end of the road. And it will just be, well, thanks so much, Mr. Sue. Hope you get on in Pentonville and be on your way when you leave. I suggest is an unlikely one. And the more likely scenario, and I say this without any imputations against the respondent at all, is that Mr. Sue will, as he did last time when he suddenly mentioned his mother having received various large sums of money, which then led to massive litigation against the mother, which has led to a judgment last week. In a lot of Lakatamia judgments the last week, let alone the last 2 years. It's a likely scenario, or at least a highly possible scenario, and I say this without any knowledge at all of the underlying facts, that Mr. Sue will answer a question put by my learned friend, which will ring a bell in Lakatamia's mind and think, well, we want to pursue that point a bit further. We want to actually get some more disclosure that you suddenly mentioned this asset or that asset. We'd actually like to look into that. And we'd like to have a third cross-examination as to means, because we need to pursue that. We need to get disclosure orders, possibly against third parties or what have you. And I suggest, and I say this without any imputation against the respondent at all, that the notion that this second means cross-examination, assuming it does take place in September, and I'm willing to accept that assumption, is not going to be the end of the line.
But that's all down the line. Then the passport order, a fresh passport order, will have to be reconsidered on the merits of fresh. This, I mean, in a way, Mr Justice Waksman's order came and went when Sir Michael Burton came on the scene in April.
Well, Sir Michael...
There's no appeal against Sir Michael Burton's order.
Not that I'm aware of.
So how does this fit in?
Well, Sir Michael made an order that it should be extended till the end of July. Mm-hmm. But he expressly accepted the possibility that Lakatamia might, before the end of July, my learned friend rises, I don't know if he wants to interrupt.
No, I'm looking for the judgment.
But Sir Michael expressly accepted the possibility in his judgment that 31st of July end date would be extended. So the notion that Sir Michael's order on the 14th or 15th of April brings an end to the matter, or my learned friend's suggestion that a cross-examination will be brought on by hook or by crook in September, does not bring an end to the matter at all. The passport order, I suspect, will roll on.
Was it resisted, the application to extend to the 31st of July?
Well, at the time, my lady, there was an extant appeal, being this appeal, which was not, I don't think anyone suggested, on my side of the court, I wasn't obviously there, that anything done by Sir Michael in April should undermine this appeal. I don't know the answer, and maybe my learned friend can assist when he stands up. But my lady, the third point is this, that this is the third point of non-academicness.
I lost the second one.
Yes.
Well, the second one, the first one was who knows when the cross-examination will come on. And my lady we've already dealt with that. And my lady said, well, show some optimism, Grant. It'll come on in September. And I'm not going to pursue that any further. I've made my submission. The second point is it's very likely, or at least possible, that Lakatamia will not be content with the cross-examination simply finishing and we'll see you on your way, Mr. Sue. And I say that's a perfectly realistic. I'm not saying that Lakatamia would be wrong in doing that necessarily. I don't know.
And so your second point is that the reality is that they're likely to want more, something will come out of the cross-examination, and therefore they will seek a further extension of the Burton passport order.
Or the Waksman order, or however you want to put it, yeah.
Which, however you want to describe it. So that is your point.
And in that context, can I just bring the court up to date on even further recent developments? There's a fourth development, which is I learnt last night that after Sir Michael had given judgment on the Wednesday of last week and Mr. Sue had gone to Pentonville, on the Thursday, that's the 8th of July of last week, my learned friend came back before Sir Michael and sought an order requiring the delivery up, and I may be putting this in wrongly, but I've not had a proper opportunity to appraise myself of what actually happened. But what I do know is that an order was obtained from Sir Michael requiring the delivery up of a mobile telephone, which Mr. Sue had apparently handed to some person in court in the RCJ on Wednesday. I think he handed a phone to somebody, and an order has been obtained requiring Mr. Sue to direct the third party to deliver it up to Lakatamia, or requiring the third party to deliver it. I don't know, but the point is this. The minutiae perhaps don't matter for my submission. The point is this, that even after Mr. Sue re-enters Pentonville on Wednesday, this respondent, this is not a pejorative submission, it's just a fact, is actively pursuing other orders against Mr. Sue.
Okay, so
I say that by way of adjunct. The third point is this.
That's all part of your second point,
Yes.
that they're likely to seek an extension. Your third point is?
My third point is this. Now, when Mr. Sue was originally sentenced in...
I am sorry to interrupt you, Mr. Grant, again, but I mean, I said to you, I'm just wondering if I'm right. Can I, because we've had so much paper, it's quite difficult actually finding where things are.
I do understand that.
And even the chronology isn't up to date. It's got all sorts of gaps in it, which isn't helpful either. I've been working... Sir Michael Burton made an order on the 20th, I mean, it's stamped the 20th, it's dated the 15th of April, but stamped the 20th, but no matter. Now, I said to you that he time limited, but that's not quite right, is it? What he did was to direct that the annulment application... I'm just trying to make sure I'm absolutely clear about what the order that we're operating is. What he did in paragraph... Well, it's not paragraph, but what he did was to direct that the annulment... I'm looking at page 100 of the court.
Thank you, my lord, yes.
Is the annulment application should be expedited and, if possible, heard and determined before the 31st of July. So that he didn't alter Mr. Justice Waksman's second order, which is under appeal, that the passport order should continue until the hearing of that examination. He just simply directed that examination should, if possible, be heard by the end of July.
Yeah, that's important. There's a misstatement, as it were, in the respondent's skeleton then.
There's no other order that... I mean, in the order committing your client most recently in July, there's no further variation of the passport order.
My lord, can I say I may not be the right person to answer that question?
Okay.
And it may be my learned friend's better.
Would my lord look at paragraph 6 of Sir Michael Burton's order of April 2021?
I've highlighted
I was just going to ask you.
I'm sure there are many inadvertent, I hope, omissions in the skeleton argument, but I don't believe this
No.
to be one.
No,
No.
okay. Sorry, I missed it. I wasn't clear. Yes, so he did both. He both directed an expedited hearing, if possible.
He could not do that, my lord, because he was sitting in a different division from the division charged with the bankruptcy proceedings. What he did do was give a strong indication that so far as the commercial court was concerned, it would be of considerable assistance if the appeal in relation to the summary judgment application to annul the bankruptcy could be brought on before the 31st
And indeed
of
it
July.
was.
And indeed, as a result of that, the Chancery Division found space for it, and it came before Mrs. Justice Bacon a couple of weeks ago.
Oh, I see. But as far as the Part 71 application is concerned, that's paragraph 6, and all he's done there is to time limit the passport order.
The passport order by paragraph 6 was limited and will expire without further application on the 31st of July. The means hearing was, the CPR Part 71 hearing, was adjourned by consent
By Mr. Justice.
by Sir Michael Burton on this occasion. The reason for that, essentially, was that there was no, because the trustees were charged with the bankruptcy, which was still extant at that point, Lakatamia took the view that it would, as it were, while the bankruptcy was still there, rely upon the trustees rather than the CPR Part 71.
Yeah, and that's paragraph 5.
So the dates were vacated by agreement between those then acting for Mr. Sue and those acting for Lakatamia, subject to the court. And Sir Michael Burton deals with this in his judgment, under paragraph 12, and said, yes, there's no point in having the hearing until the bankruptcy's been annulled.
Yes, thank you.
Thank you.
And I'm well aware that Mr. Grant is new to this, and that, but if I can help with facts, then I'm certainly willing to do that.
Can I just give my understanding, which is in no way inconsistent, I should say, with my learned friends, in respect of the Burton order of the 15th of April. Paragraph 6 is undoubtedly, as I read it, the operative paragraph. The court will see the word subject to further order at the end, and certainly my learned friend, quite understandably, did not say or undertake that he would not seek a further extension of the order. The reason why the examination as to means, as I understand it, was adjourned by consent in April of this year was because on Mr. Sue's position as it then stood, he was a bankrupt. Therefore, the judgment debt had disappeared and been converted into a right to prove in the bankruptcy, and therefore the jurisdictional basis for Part 71 had disappeared, subject, of course, to the appeal to Mrs. Justice Bacon that was subsequently upheld. I should say this as well, that Mr. Underwood, who appeared before Sir Michael in April, also applied again for the passport order to be discharged. Had another go, putting it bluntly, and that did not find favour as an application with Sir Michael. So what undoubtedly, as I understand it, and I obviously stand ready to be corrected, what is not the case is that Mr. Sue was accepting the linkage between the means hearing and the passport order, which of course was the premise originally of Mr. Justice Waksman's first order in January 2020. He said, yes, I accept the means hearing should go off because Part 71 should not be applicable, given my bankruptcy, but I'm not accepting that I should remain subject to the passport order, and a submission was made which was rejected, and there is a judgment of Sir Michael's somewhere in the bundles, where Sir Michael dismisses that. I come to my third point, which is this. Now, I went back in time to March 2019, and that's the first occasion that Sir Michael became involved in this case, I think, when there was a committal hearing. And it went on for a number of days, and Sir Michael decided that the contempts had been made out, or some of them, or most of them, or all of them, I don't know, had been made out. And he turned to the sentencing question, and he sentenced Mr. Sue to 21 months. This is in March 2019. Now, he apparently, and I think I've read this, but as I understand it, Sir Michael said, I would have sentenced Mr. Sue to more than 21 months, but I'm going to take into account the fact that he was subject to the passport order between January and March 2019. So he was subject to a form of quasi-detention. Now, he then comes to his third committal hearing in last week, and he comes to the sentencing process. And one of the submissions made by Mr. Underwood, I believe, was that, well, Mr. Sue has been subject to this passport order, which is a form of quasi-detention for many months, and that should play in the sentencing process. Now, that was not a submission that commended itself to Sir Michael, and as we know, because he was sentenced to the very maximum 24-month sentence. Now, Mr. Underwood is, as I understand it, going to be arguing the appeal against the committal sentence, and who knows what the outcome of that will be. But one of Mr. Underwood's arguments will be, whether it's right or wrong is not a matter for me to comment on, that Sir Michael erred, at least in this respect, and possibly others, and that's, I don't know, I've not looked at the grounds, in failing to take into account the fact that Mr. Sue had been subject to this detention for so many months, which is a form of imprisonment, or detention, community detention, as we put it in our skeleton argument. Now, if it were to be the case that Mr. Justice Waksman had erred in January 2021 in not discharging the passport order then it would be the case that he was subject to an order wrongly made for a period of at least 6 months, i.e. between January 21 and July 21. And that would furnish this argument for Mr. Sue on appeal as regards the committal sentence, that he has effectively been punished already through a form of wrongful detention between January and July 21, possibly before January 21. And that should play on the appeal. And one can, without wishing to invite the court to respond to the submission, but one can see the submission that Mr. Underwood might advance were I to win this or be successful on this appeal, which is this, that this court has found that the passport order had run its course and had become oppressive and disproportionate by January 21 when the matter came before Mr. Justice Waksman. It should have been discharged. He would then have been not subject to the form of quasi-detention which he was thereafter continuing to be subject to. And that should have influenced and would have influenced Sir Michael Burton, and should influence the Court of Appeal on the appeal against Sir Michael's order in reducing the sentence from 24 months down to, who knows, 18 months or 20 months or what have you. Now that argument is going to be a live and pertinent argument. And when a man's in Pentonville prison, months count. If anyone, and the Pentonville as a prison is a matter of public notoriety. I'm going to say no more about that. So that submission will be available to Mr. Underwood if this court were to agree with me that the passport order had wrongly continued after January 21. And it's a real life order.
What you say, do you, that would knock out paragraph 6 of Mr. Michael Burton's order of April?
It wouldn't have any. I say, with respect, that the April 21 order has got nothing to do with it.
Well, it has on one view, in the sense that it's an order that I mean, I know it's referential in the sense that it refers back to Mr. Justice Popplewell and then the first Waksman, the first Waksman and the first Foxton's order. But it is nonetheless, in terms, an order imposing the restrictions on movement until the 31st of July. So, I mean, would that you say fall away if we allowed the appeal?
Well, in one sense, it won't matter because but he's now in prison. There's only 15 days to go under the Burton order, because we're on the 15th of July or whenever it is
so
today.
it'll be spent by then anyway.
It'd be spent anyway. So it'd be an academic question. That would be an academic question. But what won't be academic is that if the court has found, pursuant to this appeal, that Mr. Sue should not have been subject to the passport order and the full panoply of consequential matters that flow from it, from at the latest January 21, he was therefore subject to a form of wrongful quasi-detention, and that should have substantial significance when weighing the question of sentence. Now,
So we're hearing this appeal, are we, to assist another court in deciding the appeal against the committal order?
No, your Lordship has asked the question, is this an academic appeal? And I'm suggesting it's not an academic appeal, and I've given 3 reasons why I suggest it's not an academic appeal.
And the last of the reasons is that if by deciding this we provide ammunition in relation to a further appeal yet to come on.
Well,
that's right.
That could be the effect of it. I'm not saying your lady.
No. If we decide as you would like, then you say that's ammunition in relation to a future appeal.
It merely shows it's not academic.
Can I just pick you up, please? So going back to paragraph 6 at page 101.
Yes.
Speaking entirely for myself, I cannot see that success on this appeal would in any way affect that paragraph, which really emphasises the unimportance of the second Waksman order, which isn't even referred to. So the trigger for the passport order is taken as being the order of Mr Justice Popplewell. That's paragraph 2 of the order at page 87, tab 12.
Yes.
The paragraphs 11 and 12 of the first Waksman order, that's not the passport order, that's you can't apply for a try to leave or apply for a new passport, etc. So the second Waksman order isn't even the subject of the Sir Michael Burton order. So let's say you succeed in overturning the second Waksman order, you are left with paragraph 2 of Mr Justice Popplewell's order being in place and the time extension to the 31st of July. So how does it work?
Well, it works in this way, that if Mr Justice Waksman had acceded to the application made by Mr Sue, which came before him on the 21st of January of this year, had he succeeded on that application, he would have been free. He would have been a free man at that moment. As a result of Mr Justice Waksman not acceding to the application, he was not a free man in the sense that he remained subject to a panoply of obligations, including having to go to Charing Cross Police Station twice a week, etc., etc. He was therefore, in real life terms, subject to impositions on his private life and personal family life every day that passed after Mr Justice Waksman refused that application. Those are real life consequences for him. And if that order was wrongly made by Mr Justice Waksman, as I suggest on this appeal it was, then Mr Underwood could with some force say he has been subject in real life terms to impositions which should bear on the sentence he has to serve in Her Majesty's prison.
It's your ammunition point.
But it may be an ammunition point, but it's a valid point.
I understand that, and it may go to sentence, but one can't ignore the fact, because you're not appealing, I think, but tell me if I'm wrong, don't think you're in the committal proceedings, you're appealing Sir Michael's findings that your client had breached various orders.
Absolutely not. They were admitted.
Exactly. And so, I mean, aren't you in the difficulty that although you can argue about what the sentence of imprisonment would be, you can't argue that your client's put himself in these difficulties by simply refusing to comply with the court's orders?
My lord, I don't pretend to be having full knowledge of
Well, you don't
committal
have to have
proceedings. But let me
full
say,
knowledge. I mean, it's apparent from the papers and from a variety of judgments, that some of which I've read and some which I haven't yet read,
Yes.
that your client is a serial offender in terms of compliance with. I mean, we can have arguments, or you can have arguments in the right court about what penalties that should lead to, but what you can't dispute is that all of this is dragged on and on and on because your client will never comply with the orders for disclosure and freezing orders which have been made against him.
I can't contest that.
So he's entirely the victim of his own behaviour as far as this is concerned.
My lord, that begs a question, which is that is it an answer to, and this engages the jurisdiction under the passport order, which I've not addressed the court on. It begs the question, which I don't accept has an immediate and obvious answer, that if a man is in breach of court orders, A, B, and C, which lead to committals, does that ipso facto mean that the passport order cannot be impugned or cannot be contested and simply rolls on?
What it means, well, I mean, I can see the argument that, you know, you can go on and on and on and so on, but, and of course nobody is going to say that these orders for restraining people from leaving the jurisdiction are not, as judges often say, at the very extremities of the court's jurisdiction, but in the end they are well established, subject to safeguards. And the fact of the matter is, in this case, on the material we've got, there wouldn't have needed to be a further examination if your client had been candid and truthful about his assets at the first one. All of this has been caused by him just refusing to give the disclosure he's been ordered. So he's dealing with assets in breach of the original freezing order. And that has dragged the proceedings on and on and on. I mean, you know, one can't blind yourself to this. This is, I mean, of course this is an extraordinary case for Mr. Seuss still to be, never mind the fact that he's in prison for contempt, but that he's still subject to a passport order, 2 years after he set foot in the country. But it's extraordinary on both sides. I mean, his behaviour is extraordinary. I'm
not going to suggest otherwise, my lord. I'm not going to suggest otherwise. But what I do suggest, and this possibly takes us to the gravamen of the appeal proper, is that it is not an answer to where a question is raised as to the length of a passport order, and that question is raised whether in the High Court or in the Court of Appeal. It's not an answer simply to say, he's the author of his own misfortune, pack your bags, in my respectful submission. The analysis has to be a more focused one, in my respectful submission. And remember this, my lord, there's a case decided by Mr Justice Wilson called B&B, which we put in the supplemental bundle of authorities, which have some similarities to this case, where a husband is the subject of a judgment debt in favour of his ex-wife. He arrives within the country. He is subject to a passport order against an examination on means. That order is originally made and no one contests its efficacy and rightfulness. It's made up to a date when the husband is cross-examined. And there's a matter of a few weeks between the order and the examination as to means. He gives answers to the examination, which Mr Justice Wilson concludes are false answers, and Mr Justice Wilson is absolutely clear that the husband has the wherewithal to discharge the judgment debt, but is refusing to do so. And then counsel for the wife then advances an argument before Mr Justice Wilson, as he then was, that you should continue this order, this passport order, until such time as he pays the debt, as a form of goad to paying an underlying High Court judgment. And Mr Justice Wilson, it's fair to say, is very sympathetic to the underlying philosophy of the application. And he says that if I was not constrained by the law as it stands, I would have been content to make the order. But in very striking terms, he says that if the lights are showing amber, I would have proceeded. But the lights are showing red. The law has been set that passport orders are not to be made as a general goad to try to force somebody to pay a debt.
But
Now,
I mean, the order in that case was without jurisdiction, because you can't make an order that somebody is restrained within the jurisdiction until they pay the debt. I mean, that runs flat contrary to the legislation. But you can order somebody to remain here until a particular hearing, and that's what we're concerned with on this appeal.
yes, but then the further question that arises, I respectfully suggest, is where the law has been consistent, and I was going to address your lordship and my ladies briefly on the law. Maybe you say we don't want to hear it, but I was going to show your lordship and my ladies some of the cases briefly, which were not, I don't believe, were shown by Mr. Underwood to Mr. Justice Waksman. I don't know why that was.
Well,
they weren't. And what we say, putting aside, this man is a serial contemnor, this man is doing his best to prevent Lakatamia, who has a judgment and has an entitlement to enforce that judgment, and I quite accept all those points. Lakatamia is owed tens of millions of dollars, which it has not been paid. Nothing I say is intended to undermine that point.
Yeah, and which your client could have paid. He's moved the money from company to company.
Well, I don't think there's ever been a finding, and again, there are so many judgments in this case, I may be wrong. I don't believe there's ever been a finding that he, if he wanted to, could pay.
Well, never mind.
Whatever. But what I'm trying to do, my lord, is to say that there is a difference between a man who is a contemnor on a serial basis, and I don't dispute any of that. It doesn't follow that simply saying that provides an absolute and immediate answer to an examination, and a rigorous examination of the boundaries of the passport order jurisdiction, and whether the passport order jurisdiction has been stretched to breaking point and beyond breaking point in this.
But do you, while we're on, because at the moment we are concerned to hear the argument about whether this is academic, but have I got this right, Mr. Grant? I think you say it's not academic because of its relevance to the possibly forthcoming appeal about sentence. But I think you do accept, and I can't see how you can avoid saying, that it is academic in terms of the passport order itself, because that will, unless renewed, expire at the end of this month, long before your client is free to go.
Well, not sure I do accept that precisely, my lord, for this reason, that I don't believe that Sir Michael, sitting in April 2021, was making a de novo passport order. He wasn't saying, well, that...
Never, whether he was or he wasn't, that order, whether you treat it as a new order or continuation of the Waksman order, goes at the end of this month.
Well, it goes subject to the possibility of extension.
Of course, but if it's going to be renewed, then there has to be an inter partes hearing in the commercial court where all these points about, it's gone on too long and blah, 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 can all be gone into in front of the judge. I mean, they can't get it on a sort of rubber stamp basis. They're going to have to go and justify having a further period of time with the restraints imposed on your client.
Well, if I were in my learned friend's shoes at such an inter partes hearing, I suspect what I would be saying to whichever judge was hearing it. Here we have an order which was made by Mr Justice Waksman in January 2020, continued by Mr Justice Waksman in 2021. He dismissed all the arguments that were ranged against him by Mr Underwood. It rolled on through to April. It was extended by Sir Michael through to July. Here we have a series of High Court judges and this is a point my learned friends make very eloquently in their skeleton argument served yesterday. Here we have a series of High Court judges all speaking with one voice. This passport order should stay in place. It serves a proper and valid function. And
it doesn't serve a proper or it doesn't serve a necessary function when your client's in prison. I mean, we're talking. Let's assume that the Part 71 hearing gets on in September. Your client's still going to be in prison at that stage. They don't need to extend the passport order then. Historically, in these proceedings, the passport orders tended to be, I think, extended when your client's release from prison has been imminent. Because then, obviously, he would be free to depart the jurisdiction unless some restraint was put in place. But they don't need that restraint so long as he's subject to the committal order.
Well, I don't know how
I mean, he'll be
proceed.
brought. I don't know how it'll be done. Whether it'll be done remotely or by him in prison. But one way or another, he will be available to take part in an examination, whether it's in the Rolls Building or online from Pentonville, in September.
Well, that may be right, but I don't believe, my lord, that your lordship's train of reasoning actually infringes the submission I made, which was to resurrect my first point, which is this, that if there is a continuum of orders in which High Court judge after High Court judge has extended the passport order, speaking for myself, I would take the view, as if I were counsel for Lakatamia, that provides quite a good platform coming before Mr Justice or Mrs Justice X or Y in September or whatever it might be, and I've no idea how it's going to be proceeded with, to say this is all your lordship or your ladyship is doing in this commercial court is continuing an order which has been the subject of repeated endorsement by previous judges. And that would be a submission properly available to my learned friend.
And so you want to use a decision of this court as an insurance policy against that. It's back to it's ammunition in two respects. It's ammunition, as we discussed on your head 3, in relation to the sentence, yes, which Mr Sue is presently serving, and it's also ammunition in case there's a further application to renew or extend. That's it.
My lady, I mean, that's right. I mean, okay. The word ammunition,
I know you don't like that word, and I'm sorry I keep using it, but I think we all know what we mean.
Yes. But what I'm trying to say is this is a proper appeal.
Yeah, I'm not in any way suggesting otherwise by using that word.
Thank you, my lady.
Unless there's anything else that either my lady or my lord would like to ask you, I'm very concerned now about the time because we haven't begun to deal with anything substantive if we are to do so. So unless they have any further questions of you, I think it's time that we heard Mr Phillips about the 2 issues that I flagged to start with. We've obviously read everything that you've written, so please don't feel that you have to repeat that. But there were the two issues, as you recall. One is the amendment, etc., and the other one is this academic.
Very well, my lady. I'll just begin by saying that Mr Grant and I have known one another for a very long time, and we are not, I want to make clear to the court, across one another, other than forensically. I know you didn't want us to deal with any of those points, but we understand, both of us, the necessity to help the court. Now, on the first of these points, which is the what is now a late replacement skeleton argument, and an application to amend the grounds of appeal, I'm not going to add to what we have said in writing in paragraph 7 of the skeleton that I hope reached the court yesterday, save in one regard, and that is this, to draw your ladyship's and my lord's attention to what has been said today, but what is in essence in the first sentence of paragraph 15 of the replacement skeleton argument, where my learned friends say the proposed second and third grounds of appeal identified above form part of the existing first ground of appeal.
Sorry, 15, did you say?
15 of my learned friends.
Of the new skeleton.
New skeleton.
Yeah.
In other words, there is nothing in those grounds which, if the appeal is to proceed, is strictly necessary for the purposes of enabling Mr. Grant ably to argue on behalf of Mr. Sue the points that he wishes to do so.
And so that cuts both ways in the sense that there's nothing much new in this, so why are we all arguing about it?
But then the other point, my lady, and I don't need to stress it, we put it a number of different ways, by reference to Schenges in this court, is that it's too late. And it's not a question of whether my learned friend and his juniors and those who instruct him are new to the case and have been placed in difficulties. The rules are clear and they bite against Mr. Sue. And it is he who needs to satisfy this court, in the words of Part 52, that the additional skeleton argument, or replacement skeleton argument, and the additional grounds of appeal are strictly necessary. And on the basis of what is said, that is not the position. Lady, that's the first point on which the court wanted assistance, and I need say no more about it unless I can help further. With regard to the character of this appeal and whether or not it is academic, my learned friend makes 3 points, and with respect to him, they are misconceived. The first of those points is that Mr. Sue has put in a notice of appeal, as he is entitled to do as of right in relation to the sentence that was imposed on him last week by Sir Michael Burton of 24 months.
Can you just help me? I can't remember. I mean, against a sentence of imprisonment for committal, you don't have to get leave to appeal the sentence or any of it?
As of right, he is entitled to appeal.
Yeah.
Now, that is the first point that my learned friend Mr. Grant makes as to why this appeal against the order of Mr. Justice Waksman matters. But the problem with that is that this court must approach the appeal against the order of Mr. Justice Waksman on the basis of matters as they currently stand. And as matters currently stand, Mr. Sue is in custody, as I understand it, in HMP Pentonville. And the fact that he is seeking to appeal his sentence is neither here nor there with regard to the CPR 71, Part 71 hearing, which, as my ladies and my lord will have seen from the skeleton argument, I said to Sir Michael last week must come on as soon as it can practically be done. I don't, for what it's worth, think it can be done in July, but I do think that it can be done in September. So the first of my learned friend's points as to why this is not academic, in my respectful submission, as a matter of law, simply falls away, because at the moment Mr. Sue is in custody, and he will remain in custody until the halfway point, unless and until this court interferes with the sentence that was imposed upon him. The second point that Mr. Grant makes as to why this appeal is not academic is, he says, essentially, that this will just run on, and further applications will be made for similar restrictions to be applied to Mr. Sue in the future. Well, again, with respect to Mr. Grant, that takes him nowhere, because when those applications are made, they will have to be approached by whichever court hears them on the basis of the merits of the applications as then formulated. This court cannot assume either that Lakatamia will make further applications for similar restrictions to be imposed upon Mr. Sue. It may or may not do so. I'm unable to say one way or the other. nor can it assume that if any such application is made, it will necessarily be granted. The third point made by my learned friend Mr Grant as to why this appeal is not academic is I'm reluctant to use the word, this is the first of the ammunition points, namely that a judgment of this court in relation to the appeal before it on the order of Mr Justice Waksman made in January of this year will enable submissions to be made about sentence to this court as and when Mr Sue's appeal on sentence comes on. And there are three reasons why I'm afraid that that goes nowhere. The first reason is that as at the date that my Lord Mr Justice Waksman made the order which is appealed against, Mr Sue was still subject to a custodial sentence. He had been released because there is a duty on the Secretary of State to release at the halfway point under the 2003 Act. But as and when the matter came before Mr Justice Waksman, Mr Sue was still subject to the two custodial sentences that had been imposed upon him by Sir Michael Burton.
So he was on licence?
There's no formal licence because it's not criminal. There is simply, my lady, a duty, which, as your ladyship may recall, was introduced to deal with prison overcrowding in the early part of this century, on the part of the Secretary of State to release at the halfway point. But the sentence itself is not remitted.
Yeah.
So this is an appeal against Mr Justice Waksman's judgment or order, and as at the date of that order, Mr Sue was still subject to the two custodial sentences which Sir Michael had imposed on him. The second reason why this point goes nowhere is that Sir Michael Burton, in his sentencing remarks last week, indicated that although he was giving Mr Sue the statutory maximum of 24 months, in fact, Mr Sue deserved much longer than 24 months. And in a case which is not in the bundles, in this court, involving Mr Sue's cellmate, Mr McKendrick, it's called McKendrick and Financial Conduct Authority, this court drew attention to the fact that even without the duty on the Secretary of State to release at the halfway point, the maximum sentence imposed by statute is relatively short, and that there is a broad range of conduct which will therefore call for the maximum sentence.
Well, there are lots of commentators who think 2 years isn't long enough.
Isn't, my lady?
Statutorily is not long enough.
Well, the one thing that might be said about this case is that it hasn't been long enough to break my learned friend's client's resolve. So that's the second answer to the point. But there is then this fundamental problem with the submission that is urged upon the court as to why this appeal is not academic by reason of this ammunition point. And that is that the submission that my learned friend contemplates Mr Underwood QC will wish to address to the court on sentencing is open to him, whatever this court decides in relation to this appeal. In other words, Mr Underwood will be able to submit to the Court of Appeal that as a matter of fact, Mr Sue has been stuck in the jurisdiction.
That's the relevant point for sentencing purposes.
Yes, it's the fact.
It's the fact that his liberty has been infringed.
Indeed so. And So the point is open, whatever the court decides or were to decide on this appeal, indeed, if it proceeds. So that is, again, not a reason, even leaving aside the other two reasons, for this appeal proceeding before your ladyships and my lord today.
Do you take any point on improper collateral purpose or anything like that?
Improper
Collateral purpose. I mean, is it
in other words, can
is it
the
a proper
appeal be
use
used?
of this court's jurisdiction to use the appellate process? I mean, on this basis, the appeal becomes subject to the first and second points. The appeal became non-academic last Tuesday or Wednesday.
I don't take that point, but the reason I don't take it is because the point is open to Mr. Underwood, whatever the outcome of this appeal. In other words, it would be, if the point had any merit in it, which it doesn't, then I would submit that it were an illegitimate use of this court's time. Because the point has no merit in it, because it is anyway open to Mr. Underwood, QC, to make that point on sentencing, I don't need to say, and therefore don't say, that this is an illegitimate collateral purpose of this court's jurisdiction. Can I then deal with my Lady Justice Asplin's second ammunition point, which I think Mr. Grant adopted, namely that the determination of this court in relation to the appeal against the order of Mr. Justice Waksman can, with utility, be employed in the future by Mr. Sue in relation to any further applications for restrictions on his liberty that Lakatamia might choose to make. Now, in relation to that, the first point is, of course, that this court does not know whether any such applications may be made in the future. But the second point, which is the more important point, is that those applications will be, no doubt, be fully argued on behalf of Mr. Sue by Mr. Grant, or whoever is then representing him, by reference to the authorities that are contained in the replacement skeleton argument, and that they will have to be decided at the time that they are made on their merits in relation to law which my learned friends say in their replacement skeleton argument is clear and does not require any further elucidation. The four reasons now given as to why this appeal is not academic are therefore misconceived. The appeal is entirely academic. It is, with the greatest of respect to my learned friend and those instructing him, a waste of this court's time, and it should not proceed. Unless I can assist further, those are my submissions on those 2 points.
Can I ask you, Mr. Phillips, just to deal with one point, and that's the if this appeal were to be heard substantively and resulted in being allowed, what effect would that decision have? I.e., that Mr. Justice Waksman should not have made the order he did for the reasons he did, have on paragraph 6 of Sir Michael's order of 15th of April. In other words, I mean, does it wipe the slate clean, or would paragraph 6 continue to remain in force regardless of what happens on this appeal in relation to the Waksman order?
No, my lord, for this reason, that when the matter was before Sir Michael Burton, when he made this order, Mr. Tier, not Mr. Underwood, as my learned friend said, but Mr. Tier applied for permission to appeal against this order.
Yes.
And I opposed that application on behalf of my client. And one of the things that I said was that if this court overturned Mr. Justice Waksman's January order, then the restrictions would fall away.
So you accept that the Waksman appeal would wipe the slate clean as far as this is concerned?
Yes, because that is, I mean, I didn't make it by way of a concession. What I said to Sir Michael was that if this court overturned the order of,
Yes.
forgive me, if this court allowed the appeal against the order of Mr Justice Waksman, then the restrictions on Mr Sue's liberty, apart from obviously the custodial sentence that has been imposed on him, would fall away.
I mean, I don't want to open this up now because these are arguments for the substantive appeal, but of course it might depend on what basis we decide. I mean, assuming we allowed the appeal, we allowed it because, I mean, if the appeal were allowed on a fundamental basis that it was all just too long and, you know, gone on too long, which is what Lord Justice Mayles, I think, had in mind, well, of course, that would be an answer to everything. But if Mr Justice Waksman misdirected himself in some other respect, that might put us in the position of having to re-exercise the discretion that was in front of him at that time, ourselves.
Indeed, and at that stage I would be making submissions as to how that discretion should be exercised. It would obviously depend upon the manner in which the court disposed of my learned friend's appeal.
Well, of course, that's why I don't think we can usefully go into the
and of course, then, I mean, one can contemplate, although they are perhaps remote, circumstances in which, having disposed of the appeal in my learned friend's favour, some form of further application might or might not then be made to the commercial court. But the reality of the position is that, as we wrote, as your lordships will have seen, in correspondence to my learned friend's predecessors, or the predecessors of those instructing my learned friend last week, there is no point in this appeal anymore. And in my respectful submission, if the court were of that view, then the appropriate course is not to proceed with the substantive appeal.
Yeah.
But that's my submission. It's a matter really for the court.
And that's the letter at page 32.
Of the clip
Of
we enclosed
the enclosures to your skeleton argument.
Yes, I think that's the one. It's paragraph 4, I think. Now, to that came there no answer other than no, there's utility in the appeal, as your ladyship will have seen from an email, which I think follows that on the following page. My ladies, my lord, unless I can assist on the two provisional questions further, those are Lakatamia's submissions.
Thank you very much. In relation to those submissions, do you have a reply?
My lady, I was going to reply very shortly indeed. Particularly to the two ammunition points. Brackets, I don't accept the phrase ammunition, but I'm using it for their bene esse.
Shorthand only.
I'm entitled to say that. My learned friend had 3 points in relation to my sentencing ground. First, he said that in January 2021, when the matter came back for a second time before Mr Justice Waksman, my client was still subject to a custodial sentence. I don't accept that. If one looks at, and your lordship, my ladies and my lord has section 2258, I don't know whether you want to look at it, it's tab 17 of the original bundle of authorities. I'm conscious there are 3 bundles of authorities now. It's the original one. It's a slimish volume. Your lordship, my ladies will see that it's tab 17, and there's section 258. I don't think I need to gloss the section. It's a meaningless proposition, in my respectful submission, to say that if a person is subject to a 24-month sentence imposed by the High Court for contempt of court, and they are then released as they are statutorily entitled to be, no buts, no ifs, no provisos, on the 12th month, at the end of the 12th month of their sentence, they are then as free and unconstrained by the court's custodial jurisdiction as any other citizen of this country. The concept of the sentence persists means something in the criminal sphere. I tread softly, because, as I understand it, if you are released early for a criminal sentence, there are circumstances in which you might be brought back to court or brought back to prison if you misbehave in the second part of your sentence. Or when a person is sentenced to prison for murder, for instance. They are released after 12 years or 15 years, but the life sentence continues till they die. Because if they then breach the criminal law thereafter, they can be brought back and required to continue serving their sentence. So the short point is, it is a meaningless proposition to say that Mr. Sue was in January 2021, when he was living in his squalid flat in Maida Vale, wherever it might be, he was, quote, still subject to a custodial sentence. Had he been, he was subject only to the passport order. He was free to do exactly as he wished. There were no constraints on him whatsoever as a result of Sir Michael's earlier sentences imposed in 2019 and March 2020 or February 2020. That's the first point. The second point, my learned friend says, is that, well, Sir Michael said that 24 months was too short, and had he had his way, he'd have been banged up for I don't know how long. I don't understand that point with respect. The statutory maximum is 24 months. The sentencing process does not start as follows. The sentencing process on a committal is not for the court to say, well, subject to parliamentary constraint, I would have sentenced this man to 10 years in prison. And therefore, because I can only sentence him to 24 months, I'm giving him a reduction for his guilty plea of 8 years. That's just not the way that sentencing occurs in committals. Undoubtedly, it is the case, as McKendrick says, that one does not confine 24 months to the absolute most heinous contempts imaginable. And it may well be that that's a ground of appeal itself, the way that Sir Michael expressed himself. I don't know. It might be. One can concede that. But what my learned friend is seeking to do by his second point under this head is to say that never in a month of Sundays will the Court of Appeal be impressed by this point, because Sir Michael took the view that this man should be in prison for much longer than 24 months. That would be a bad submission, in my respectful submission. But in any event, Your Lordship, my lady doesn't need to consider that question. Now, all I'm saying, I'm not asking you, my lady, to preempt what any court might say to Mr. Underwood's submissions. All I'm saying is, it is a arguable ground of submission to run. And that takes me to my third point, or rather my learned friend's third point, which is that, well, Mr. Underwood, whether or not the Waksman order of January 2021 was bad or not bad, Mr. Underwood can still say that as a matter of factual reality, he was living this miserable half-existence in a one-bedroom flat with no furniture in it in Maida Vale, which he happened to have the benefit of from his friend Mr. McKendrick, who we've heard about. Now, that submission, I'm sure, was made by Mr. Underwood last week to Mr. Justice Burton, or to Sir Michael, I should say. Didn't appear to have had much traction with Sir Michael, it's fair to say. But in my respectful submission, and certainly if I were to be arguing the appeal in place of Mr. Underwood for whichever division of this court hears it, I would be urging very strongly, if your ladyship was with me on this appeal and were to dispose of it favourably, I would be saying it's one thing for a person to be living in a miserable half-life in Maida Vale, pursuant to a rightful order made by the commercial court. It's quite another thing for it to be a wrongful order. And that has traction. And what my learned friend is trying to do is essentially say it's a rubbish argument, you don't need to worry about it. It is an arguable point, which certainly professionally I would be running were this court to uphold this appeal at any appeal against sentence. Those are the 3 points my learned friend makes as regards sentence. As regards the second ammunition point, my learned friend says, well, who knows what we'll do in the future? Who knows what arguments we'll run? Who knows what applications we will make? But if we do make them, then whoever is appearing for Mr. Sue at that time will be able to say, well, look at Bayer and Winter, look at B&B, etc., etc. And it may be that whoever is appearing for Mr. Sue, if anyone's appearing at all, will show those judgments and make arguments founded on them to whichever commercial court judge is dealing with it. But the reality is, but this is the reality, that if that judge is faced with a continuum of orders, time and time again, upheld by High Court judges, they are likely, in my respectful submission, to take the view that the application to extend it yet further, it having been lawfully in place and endorsed on many occasions, so it will be said by my learned friend, I suspect, they are likely to be swayed by that. Whereas if this court has said today, or whenever it gives judgment, Mr. Justice Waksman in January 2021 should have said, and I'm summarising the submission, enough is enough. This passport order originally made, whether by Mr. Justice Bryan in 2018 or by Mr. Justice Waksman in 2020, there are arguments about precisely when this order originally incepted, had gone on too long, and that the jurisdiction had been stretched to breaking point by January 2021. And Mr. Justice Waksman should have brought it to an end there and then, for all the reasons which I have sought to deploy in my new replacement skeleton argument. Then can it be said it is beyond the wit of the advocate acting for Mr. Sue to say, if my learned friend stands up again and says, I wish to have a further passport order, or an extension thereof, or what have you, a judgment of this court saying that is likely to carry some weight. So it's not academic in my respectful submission. And finally, my Lord Sir Nicholas referred to the question of the Burton order and said, well, what would happen if we were to allow the appeal against the Waksman order?
Well, I think it's accepted that it
Well, it's accepted it would fall away. So that would have a real life consequence in that sense. The final point, and I don't want to press the point too vigorously, is of course there would be cost consequences. I don't press it too vigorously, given that my client is a debtor to the tune of $60 million. It may be 70 now, I don't know. And my lady may think, well, that's a relative drop in the ocean compared to the overall debt that my client is subject to. Those are my submissions, unless I can assist this court further.
Thank you very much. I think we will rise for a few moments. Thank you.
All right.
Should have replied to your email last night. No. Fine, you want to do it. Yeah, go on. On the substantive merits of the appeal, it's got no more than about 15 minutes. Well, I just been very short. There's no point in pushing it an open door, if indeed it is an open door. Yes, I should perhaps. Well, but then the starting point for that is that you've got to conclude that it is active. And if we don't agree to it going ahead, then it doesn't go ahead. It's all right. It's your function. One of your many functions. That and churning out amazing skeleton argument. All the grades done now.
No, there's another meeting, one last meeting tomorrow.
Can I give you a list of people I think deserve a first?
The results get released on Tuesday, so tomorrow we should have finished on.
Who decides the binarian? That's the BCO.
That's the BCO, yeah, that's a different example. So that's the, there's a, I'm not part of that one, but that's the, there'd be a BCO example. But that's the only important decision that example has to make. It'll go for a day.
Well, in my years, when I did it, they have to make a decision whether you get a first or a second. It was an undivided class when I did it.
They'll still make that decision. But, you know, the only really significant one is the binary.
But I didn't.
No, neither did I. I didn't know. Who got it in your year?
I have no idea. Oh, yes, I do actually. What's his name? Law fellow at Magdalen.
On,
Not Roderick. I completely forgot what his name is.
Law fellow at Magdalen.
I think he's at Magdalen.
Because Roderick is a Magdalen, but he's not. He wasn't a binary.
Oh, I thought it was him. My namesake in the Court of Appeal won it. The real Stephen Phillips. I hate it when they don't say and will come back out. Because, is there time for a pee? Isn't there time for a pee?
So I might be keeping it.
Oh, no.
Russell, yeah.
Russell can't watch. Or can he?
It's being live streamed.
Sorry?
It's being live streamed.
Oh, yes, I saw some email about it. What does that mean?
He's been able to get in. It's because they can only allow 8 people in, so anyone not on the team
Oh, I
can't
see.
come in later.
Confirmed?
Yes, Liz. Hello. Sorry. Maybe it's slightly late, so I've just left the room. Oh. No, no, no. Oh, that's okay. I thought it was me. Thank you.
Well, I only looked at the one that I sent you, and the one that's referred to in it. Which is a Scots case, I think.
Yes, it is. I love what they do. What they do when they allow an appeal in Scotland, what's the word they use? Because you set aside the order below in Scotland,
Everything's different terminology. They still have defenders and pursuers.
they've still got
There are actually some very, very good lawyers in Edinburgh.
I think
Angus Glennie, who was at Brick Court, he was quite successful still, and was also an advocate in fact. Went off to become Lord Glennie. I think went all the way to the
Got Rose?
Well, first of all, I can tell you that we've decided that we will go on to hear the substantive appeal today, despite the fact that we're now quite short of time, and so you're going to have to divvy up your time very carefully between you. And the second conclusion that we've reached is that we give permission for the amendment to the grounds of appeal and for reliance on the skeleton, whatever one calls it. And we do so because overall we consider that grounds 2 and 3 are teased out from ground 1 in any event, and there's no injustice or prejudice which is caused. So with that, and as I say, with very limited time now, Mr. Grant.
Thank you very much, my lady. I will...
I'm sorry, as my... as Lady Justice Carr said, we will obviously consider the issue of costs in relation to this morning's applications separately and later.
Thank you, my lady. What I was going to do, first of all, before coming to the facts of the case, of course, the court has heard something about those facts already, and I will endeavour to, when I come to the facts, to take that into account. I thought it might assist the court if I was just to turn briefly to the authorities, which I think it's right to say, and Mr Justice Waksman was not provided with by Mr Underwood and Mr Tier, and therefore they don't feature in his ruling, in his judgment. The passport order was invented, that's the right phrase, by the Court of Appeal in 1986 in the famous case of Bayer and Winter. There had, of course, been, before 1986, an old writ, re ne exeat regno, as it was known. That writ had fallen into desuetude, I think it's fair to say, over many decades. It was reconsidered by Mr Justice McGarry in a case called Fenton and Collis in 1969, albeit Mr Justice McGarry had concluded that it had very limited utility in the modern day. The matter came back before the court, as I say, in Bayer and Winter, where the applicant sought Moreva and Anton Piller relief and sought a very short, this is tab 3, I should say, of my authorities bundle. When I say my authorities bundle, it's a rather thicker black bundle, which extends to 13 tabs.
No.
I'm sure it does, but still.
I'm worried about
And
that.
you were taking me to us to tab 3, and I have got the wrong bundle.
I think Sir Nicholas Patten, that might be the right one. It's a sort of thick black one.
Yeah, I've got rather confusingly, I've got what are called bundles 1 and 2, but I believe
bundle 1 is the original agreed bundle before I came on the scene.
I
think
think
it may
one
be
that
bundle
begins
2.
with Geraldine Finnegan's application.
That's not the bundle I'm looking at, actually. That's the original bundle.
Bundle 2, Appellant's Supplemental Authorities, has at tab 3 a Bayer and Winter.
That's the one. Thank you, my lady. That's exactly it. I'm not going to spend time going through the case because I suspect it's pretty well known to the court. It was an interlocutory appeal without representation by the respondent because it was an ex parte application which had been refused at first instance, and the applicant plaintiff went straight to the Court of Appeal. It was heard by 2 judges on that basis, and it was effectively a passport order was sought, as is now known, to prevent Mr Winter, the unsuspecting respondent, leaving the country and having to hand in his passports until he had provided information which was being ordered also at the same time, in which there was no contestation by the High Court judge who decided the matter originally, they should be entitled to. The real question was whether there should be an ancillary order made requiring Mr Winter to remain in the country until he had provided the relevant information which was to be ordered. The fear was that he would flee and thereby evade the substantive orders of the court. And again, I'm taking this as shortly as I can, page 503 of Lord Justice Fox's decision between B and D is the operative words that I draw the court's attention to. Words that I should say have been quoted a number of times.
Sorry, which page?
Page 503, my lord. It's 139 of the external pagination, 1503 of the internal pagination.
And it's the point that it should be a very limited duration.
That's exactly it. It is an interference with the liberty of the subject. And your ladyship will see that the red lining, which is where I'm inviting the court to look at. That is Bayer and Winter, and I'm taking this shortly. The next case in chronological terms is B&B, tab 1 of the same file. And that's the decision of Mr Justice Wilson, as he then was back in 1997. I've already outlined the facts of that case, and the only passage I was going to invite the court to have a brief look at is at external pagination 8 and 9. And starting at C of page 8, the court will see that having done a consideration of the previous authorities, including, of course, Bayer and Winter, and Mr Justice Wilson quoted from the passage I've just shown the court, from Bayer. He then says, the jurisdiction exists where a hearing is shortly to take place. The efficacy of which would be frustrated by his respondents, that is, absence. In my view, it exists in principle in aid of all the court's procedures leading to the disposal of the proceedings. I don't think I need to trouble the court with the remainder of that paragraph. I then pick things up at F, where I part company with Mr Mostyn, who was the counsel for the wife, as he then was, is upon his submission that Section 37 enables a debtor to be restrained from leaving the jurisdiction not simply as an aid to the court's established procedures for enforcement of a judgment, but as a freestanding enforcement procedure in its own right. He asked that this husband, that's the judgment debtor, the person in Mr Sue's position, so to speak, be kept in England and Wales indefinitely until the costs are paid. Cost being is just a court order saying you must pay X £1,000. He defies the emphasis in the reported cases upon the short-term nature of the restraint. Mr Mostyn suggests that a restraint upon leaving England and Wales is wholly unlike imprisonment. I disagree, and I respectfully endorse that and promote that disagreement of Mr Justice Wilson to the court today. I should say this, that of course there are passport orders will have differing impacts on differing types of person, and Mr Winter was as I understand it, a British national who lived in Britain. This gentleman, this husband in B&B was a foreign national who'd arrived in the country, just as Mr Sue did in January 2019. I go over the page and essentially invite the court to take into account, I don't propose to read it out in full unless the court would like me to, all the way down to E of the second page, that's page 9. and then perhaps just cast a brief eye on the end of G, at the end of G, which is a passage we've quoted in our skeleton argument.
Okay, so you can't make an order until the judgment debt's paid, or in this case, a costs order paid.
That's what the learned judge said.
Yeah.
The reason we cite that, my lord, is because we have detected in some of the evidence put forward by Mr. Gardner, we've quoted it in our skeleton, I'm not going to take the court to it, a sort of attitude of mind that this passport order is part of the overall approach to enforcing the judgment. Now, I'd say this immediately. I completely understand, I'm not criticising Mr. Gardner, I completely understand why he might think this man, Sue, owes a very large sum of money. Let's do everything we can to force him to pay the debt. I understand that, but the law is different to that general attitude. One could conceive of
that's not the order which Mr Justice Waksman made.
not the order,
And
not the
this
first
is an appeal
order.
against the order, not what the solicitor thinks its purpose was.
I didn't hear that, but I'm sure you're
It's
right.
not a. I mean, we're not concerned. We're not with what the solicitor. I mean, parties for all sorts of tactical reasons get orders, but we are concerned with whether the order that was made was wrongly made.
The sole point I wish to make is this: that Mr. Gardner puts in a witness statement in front of Mr. Justice Waksman in January of 2021 in response, and part of the point. Some of the points he makes in that witness statement is this passport order should remain in place because it's an important part of the whole apparatus and mechanism for trying to force this man to pay the debt. I understand the underlying rationale of Mr. Gardner. The sole point I seek to make is that's not the rationale of passport orders, which are a different beast and serve a particular purpose. And one can conceive of a law which says it should be wider. That's not the law. And I don't believe my learned friend is seeking to extend the law to say it should be. My lord, that's, my lady and my lords, that's B&B. And I wanted to say no more about B&B. The next case in time is Kuwait Airlines and Iraq Airlines. And I'm afraid that requires the court to pick up Bundle 1, which was the original bundle, the one with Finucane as the first decision. And it's tab 3 of that original bundle of authorities. Again, I'm going to be as hasty as I can about this. This was the case where Kuwait Airways, of course, had a vast debt, and there was, of course, substantial litigation in this jurisdiction against Iraq Airways, a vast debt which was largely unpaid. The de facto the sort of CEO figure of Iraq Airways turns up in England, and Kuwait Airlines think, let's keep him in England so we can cross-examine Captain Khalifa, as I believe he was, Kifa, sorry, as an officer of the judgment debtor. And Sir Andrew Smith was concerned about such an order, made it and then revoked it. The matter then goes again on an interlocutory ex parte appeal to the full court, including Lord Justice Wilson. And there are just a couple of passages, which again I won't read out. First of all, paragraph 32, which is redlined, or just a little part of paragraph 32, which is redlined, of the judgment of Lord Justice Ricks. Then I invite your lordship, the court, to go to paragraph 36, not redlined, I'm afraid. May not say much more than this court knows full well, I accept. And then paragraph 40. That, of course, was a case where A, Captain Kiffer was not the judgment debtor, he was the chief executive officer of the judgment debtor, albeit the court took the view that there wasn't much between them. And B, it was a matter of relevance that Captain Kiffer had no connection with the jurisdiction. The third point to make is that Bayer and Winter was treated as the prevailing authority. And of course, passport orders are known as, by some, Bayer and Winter orders.
So the judge had refused the order, had he? I'm sorry, I'm just trying to...
Well, the judge had decided he would make the order. There was then a hearing on the telephone on the Sunday after he'd made the order on the Friday, where he essentially got cold feet about it.
What, and then set it aside?
Well, I mean, whether he set it was his own order, he just basically revoked it in some way.
And anyway, the Court of Appeal reimposed it.
The Court of Appeal reimposed it, albeit subject to various various provisos. But accepting that its reach, the order's reach, should be a very narrow one, temporally speaking. I'm afraid we go back to my own bundle. In point of time, we go to Mr Justice Voss's decision, as he then was, in Jennington. That's tab 5 of my thicker bundle. Again, I'm simply not going to take the court through the facts of this case. It's a kind of standard fraud claim, suite of orders. We want a cross-examination on means. They're not providing it. We want to keep the man in the jurisdiction so we can cross-examine him. The only paragraph I invite the court to look at is 65 brackets 2, page 170 of the external pagination. Claimants are seeking essentially cross-examination on the affidavit of means. Their passports have been impounded, and I just invite the court perhaps to read little 2 at page 170, where one will get a flavour of Mr Justice Voss's thinking about the proposal to extend the order. And if I may just make two observations about that. First, Mr Justice Voss, in my respectful submission, correctly identified the rationale and the reach of such an order. Your Ladyship will see that he quoted the particular phrase of very limited duration from Bayer, which I've already shown the court. And he said this, that, and this is the last sentence, it would be open in due course to the claimants to ask for their passports to be retained, that's the defendant's passports to be retained for a further order on the grounds that the cross-examination was unsatisfactory. Of course, rather similar to here. The first means cross-examination was deemed by the claimant to be unsatisfactory, hence they sought a second one. Such an application would be a difficult one to sustain now that these defendants have been prevented from leaving the United Kingdom for some 2.5 months. That was the view that was taken by Mr Justice Voss in that case. The next case is Young and Young, which we're back in, I'm afraid, I'm so sorry, back in the first bundle of authorities. Tab 6. And Young was, of course, a case of some notoriety at the time, involving a gentleman called Scott Young, who was involved in a protracted dispute with his wife. And it was a case where, if we go to tab 6, it's not, I don't believe it's paginated externally, this, so it's page 200, we will see that the husband appeared in person before Mr Justice Mostyn, who'd been arguing a particular position in B&B 10 years earlier, now sitting as a High Court judge, of course, husband in person, and the wife comes before the court with the considerable benefit of Mr Fitzgerald, Queen's Counsel, and Ms Bangay, Queen's Counsel, as her advocates. And again, the facts are pretty far removed from this case. It would appear there that the husband had consented to some form of passport order for some considerable period of time. So the matter had gone by consent. We see that at paragraph 1 and paragraph 2, I think, of the judgment. The wife was seeking an extension to trial. This is a pre-trial case. And Mr Justice Mostyn, having considered the authorities, and it's fair to say he considered not only the Bayer line of authorities, but also the Felton and Callis line of authorities, and also Section 224 of the Supreme Court of Judicature Act 1925, which is paragraph 14, page 203, which is a clanking relic of the Debtors Act. Not entirely clear the basis on which he exercised the jurisdiction in this particular matrimonial case, but nonetheless he sets out his understanding of the law at paragraph 26, and there are 5 or 6 Roman numerals, and the one which I place reliance on is the one which is redlined at Roman 2.
I mean, they're all saying the same thing, aren't they?
Well, I'm just simply hoping to assist the court in just showing. I mean, you'll be pleased to know that my tour d'horizon is getting to the horizon in short order. And possibly I should just say this, that in that case, the judge was persuaded to extend the passport order by another 9 months. I should say that, paragraph 33. And the court can read what Mr Justice Mostyn said at 33. And what I would say about Young, before I leave it, is that the restraint was made against a British national who lived in England and whose expressed desire to have his passport order removed was in order that he might go and participate in charitable works in Africa, ambition which it's fair to say Mr Justice Mostyn treated with some degree of scepticism. One might understand why. The last case is Corbière and Sue. That is Supplemental Authorities Bundle, i.e. the thicker one, tab 4, the decision of Mr Justice Zaccaroli. Again, I'm not going to go through the facts which are very particular to that case. We have quoted paragraph 31 in our skeleton argument. It may be I don't need to take your ladyship's and my lord through it again. But for the note, it's page 146, external pagination, and again...
Sorry, where are we now?
Tab 4, supplemental bundle 146.
Bundle 2.
When I say supplemental, I mean bundle 2, I'm so sorry.
And you were taking us to which paragraph? 31.
Paragraph 31, my lady. And we've quoted this in our skeleton, so I don't propose to take the court through it. I just thought as a finishing up, there have been other cases in which the Bayer and Winter order has been considered, but we took the view that the other ones were rather more adjectival in their consideration of the jurisdiction, and we didn't need to place them before this court. Before I leave the law, can I just make one proposition, which is maybe something I've already hinted at, which is that when considering the ambit, temporally speaking, of a passport order, it is proper, in my respectful submission, to take into account the difference between a person subject to an order who is a British national ordinarily resident in Britain, because the intrusion on that person of a passport order is likely to be very significantly less than the intrusion of a passport order against a person who has no connections with the jurisdiction, who is a foreign national, and who has no family life.
But I thought his bankruptcy application was on the basis that he was ordinarily resident, and he's appealing the annulment on that basis.
Well, let me address that. That's a point my learned friends have made in their skeleton argument. Let me address that point immediately. My lady, Mr. Sue, I should say, he did not seek my advice when making his bankruptcy application. I do not act for him in that respect. My understanding of the underlying issues is limited because I've had a vast amount of reading to do to be able to assist this court this morning, and that reading has not extended to the outer reaches of bankruptcy law. However, I do understand that he applied, as a matter of fact, he applied online last July to bankrupt himself, and I don't think he did it with the benefit of legal advice, so far as I'm aware. He was sitting in his flat in wherever it is and did that. And apparently one can do it by way of just typing into one's computer, so to speak.
So why did he do that?
I've no idea why he did it, my lord. Since I've been instructed, he's been in prison, so I haven't been able to speak to him, regrettably. One can't phone a man in prison.
No, you could go and see him, I suppose, or your solicitor could, anyway.
Well,
anyway, he resisted the application to annul.
he did, and my learned friend prevailed on that.
Yes.
The sole point is this, my lady. Just because somebody says, as a result of being forcibly detained in this country by reason of two matters, one is a passport order or succession of passport orders, and two is a term of imprisonment, which in actual terms has extended to, I think, 13 months or so, i.e. half the total. It might have been 12 months. The fact that he then says, well, therefore I'm forcibly resident in this country, doesn't turn what would otherwise be a infringement of his Article 8 rights or an infringement of his common law rights, because the common law existed before Article 8, and Bayer and Winter reflected exactly the same form of considerations that Article 8 now reflects. Let's not say that 1999 suddenly changed everything. Bayer and Winter is already ahead of the game in that respect. Just because a man says in his application to bankrupt himself, I am resident here because I'm falsely resident, it doesn't affect the strength or weakness of the submissions that I now make. My learned friends, of course, said, rubbish, you're not resident here at all. And that was the ground on which they succeeded before Mrs. Justice Bacon. So they take the view it's a nonsense that he is resident here. That's a matter of law. And as I understand it, I don't pretend to be a great expert on the law of bankruptcy, but as I understand it, the question of residence for bankruptcy purposes is a technical question. It's not based on where your home life is. It's not based on where your children might be or where your spouse might be or whether you have your clubs or your interests or what have you here. And the facts are the facts. Nobody disputes. My lord is going to say something.
No, I'm trying not to interrupt you.
No, your vote, my lord, is...
I'm not clear what this point that you're at the moment goes to. I mean, is this that it goes to Article 8?
No, I'm just answering my lady's point, which is, the lady says, well, what your client then says he's resident here. And that goes to the question of the extent of the intrusion of a passport order.
Well, that's why I thought you were on Article 8.
Well, I was just trying to answer the question.
I mean, the only question I was going to ask you, Mr. Grant, is, I mean, we haven't got any evidence, have we, from your client about his private life or home life or any of the factors that are material to...
You do, and I'm going to show you...
Oh,
I was going to go straight to
All right, okay.
The sole point I was going to make, which I've probably made sufficiently, is that the intrusion of a passport order is not just a singularity. It depends on the nature of the person so injuncted. And one just bears in mind that in Bayer, the man injuncted, Mr. Winter, was a British national, and even there, the Court of Appeal suggested that any restraint should be of, quotes, very limited duration.
Yeah.
And I say we are a fortiori here when we have a foreign national. My Lord raises, if I may say so, an important question, and I was immediately going to turn to that, which is it's important for the court to understand the position of Mr. Sue during the relevant period. Now, can I just give the the court a bit of chronology. You've had quite a lot of it, but I'm going to give you some chronology because there are a lot of facts in this case, procedurally speaking.
Can I just,
Yes.
I'm sorry.
No.
And I'm saying this to both sides. I think, speaking of myself, I'm sure it will be true for the unmembers court. We're obviously I imagine, going to have to reserve judgment, but between you, you're going to have to produce an up-to-date, detailed, comprehensive chronology with all the relevant procedural orders and so on, and so far as possible, if they're in the bundles, reference to where they are, so we can see.
We'll do that, my lord. I'm hoping, I'm going to run through it during the course of my submissions, and those will pretty much be my submissions, but we'll produce a document in writing and agree it as well.
Yeah, thank you.
I think there is, it may not be, I've seen a document produced, I think, by my learned friends, which I found very useful.
Well, there is one, and I was working through it, but there are a number of gaps in it, and
yes.
That's all I'm saying. I'm not criticising it, but I just think it needs to be brought up to date, that's all.
Let me very briefly, comforted by the fact that the court will be assisted by a more comprehensive chronology, run through what I perceive to be the key events which inform the next question which my lord raised, which is, what do we know about this man?
Yeah.
He arrives, the judgment of Sir Jeremy Cook is back in 2015, and he loses a case, and he loses it substantially, and is subject to a very large damages order. That's back in 2015. Mr Justice Popplewell makes an order in January 2018 while he's out with the jurisdiction, and that's within your lordship, my lady's bundle.
Yeah, I'm looking at page 17 of the core bundle, where what chronology we've got so far. If you see.
Yes, thank you. He arrives at Heathrow Airport on the 10th. He is immediately detained or arrested. He says he's going to stay he stays at the, this is set out in much greater detail, but I don't want to be seen to be hiding away from facts which might be said to be contrary to to paint my client not in the best of lights. He stays at the Intercontinental. He then takes a taxi to Liverpool. He apparently seeks to flee to Northern Ireland. Rather than just buying a ticket, he says to the person at the kiosk, "I know the owner of Stena Lines. Please give me a free ticket," which excites their suspicion.
Yes.
And they call the police, and he's brought back to London. He goes before Mr Justice Bryan, who makes an inter partes continuation of the order. He is then detained in London. He's handed over his passports in January 19. He's then cross-examined as to his means in February before, I think, Sir Michael Burton for 2 days. The litigation is continuing apace. He's already been the subject of a committal application, which was made very shortly thereafter. He is committed to prison on the 29th of March by Sir Michael for 21 months. He's then in Pentonville for the remainder of 2019. We then come to the first important order for my purposes, which is the Waksman order of the 30th of January 2020. And I think it would assist the court just to have a brief look at that at this stage. Yeah. It is tab 13, page 90 of the core bundle. And there's quite a lot of recital, which we can pass over, I think. And we get to the nub of it at page 94. And let's just recall, at this stage, Mr. Sue is still serving his first sentence of imprisonment under the committal order, the first committal order. He is brought up, I presume, from prison. I don't believe he is represented, and I'll be corrected if I'm wrong on that.
He had a Mackenzie friend.
He had a Mackenzie friend. Thank you. And Mr. Justice Waksman makes provisions as regards the next committal, which is rounding the bend, which is shortly to be heard, I think. He also makes the passport order, which is, or continues it. And we see that at paragraphs 8 and 9.
So, I see. So, sorry,
1 to 7 is all committal, but this is the next committal which is revving up at this stage.
So he gets here in January 19.
Yes.
Arrested in Liverpool, surrenders his passport, and then in March 19 he's the first committal sentence 21 months by Sir Michael Burton. So from March 19 right through till April 20, is it?
Yes, he's actually released on April the 9th, I think.
So at the
2020.
time Mr Justice Waksman makes the order under appeal, is that right? He's still in Pentonville.
No, we're now in the January 2020 order, which is not the order under
this
appeal.
is the first Waksman order.
Absolutely, my lord.
Yeah, I see. Yeah.
And-
But at the time of that order, he's in prison.
In prison, Mackenzie Friend, before Mr Justice Waksman, paragraphs 1 to 7 are the next committal, the second committal application, which is, as I say, revving up. Paragraph 8, Mr Sue is required to attend court at a date to be fixed in accordance with paragraph 9 to provide the court with information about his assets and means, the means hearing. So that's the second means hearing, there having been a 2-day cross-examination back in February before Sir Michael Burton. We go over to page 195, paragraph 9, and this is a point I've already made. But I'm showing your lordship now, my ladies, the actual order. By 4 p.m. on the 3rd of February, which is just a few days after the order was made, there's a listing appointment so that the means hearing to be listed as soon as reasonably practicable. And we would respectfully suggest that that is in accordance with all the guidance that I've possibly laboriously taken the court through about if you're going to make a passport order, it has to be linked to a substantive order, and that substantive order has to come on ASAP because of the intrusion on a person's liberty. That's paragraph 9. Paragraph 10 is I don't think we need to worry about. I think my learned friend may say we do. Please read it. And then paragraph 11 is the passport order, so to speak.
But it's not the surrender order.
Well, it's already been surrendered.
Yeah.
Passports. So in fact, it's rather than surrender your passports, is don't ask for them back. That's B. And then paragraph 12 is an aspect of the order at 11, and that's the paragraph that says that once you're out of prison, you've got to go to Charing Cross Police Station every day, Monday through Sunday. And I think that's all I need to show the court, unless my learned friend wants me to take you to anything else in respect of this order, the January 2020 order, what is known by everyone as the First Waksman order.
Yes.
Thomas,
Yes.
just in answer to my lady's point, if you look at 17, B and C, those are the orders which surrender the passports.
17 B and C.
Yes, the Popplewell order being
Yes.
your ladyship has the Popplewell order at tab 12.
Yes, thank you very
You
much.
don't have the Bryan order, but I don't think that's necessary.
No.
But that's the one made after the flight to Liverpool.
Thank you very much.
Thank you.
So that's made in January 2020. We move on. There's then another committal hearing which takes place, I think, in February. I'll be correct if I'm wrong. And that's when Sir Michael sentences Mr Sue to another 4 months in prison. So if you aggregate the 4 months and the 21 months, that's 25 months divided by 2, 12 and a half months in prison. So he then comes out, if one does the calculations, on the 9th of April. However, there's an important event that takes place before that, which my Lord Sir Nicholas has already referred to, which is that as anticipated by Mr Justice Waksman, the second means hearing is listed on the 25th of March. I'm sorry, on the 30th of March. Now, the claimants themselves do not want that means hearing to take place on the 30th of March, because they wish to undertake further steps in terms of girding themselves with more documents or what have you. They seek to adjourn that hearing, and it is right to say that Mr. Sue consents to the adjournment of that hearing. At the time he is, and I make the submission, he is unrepresented and in prison. And he uses, apparently, I've not seen the actual order, but he apparently writes on an earlier draft of the order or somewhere these words, I quote, "on the basis that it seems unlikely to be effective hearing," end quote.
I think we've got it somewhere, but
I don't think we have the actual words. We've had them quoted by my learned friends in their skeleton. I'm not sure I've seen the actual
I think I have seen it.
document. But if my learned friends can give me a reference, maybe I'm behind the.
Maybe in the exhibit to the witness statement.
I don't want to.
No matter.
But if I can be, I mean, I'd like to see it because I mean, for this reason, I take it as short as possible. My learned friends say, well, there he is, consenting to the order, and not only that, they say those words which I've quoted show that he accepted that a means hearing, that he would lie at the means hearing, and therefore it would be an ineffective. It would be somehow a pointless hearing. I obviously speak as a stranger to this litigation until last week, but I just make 2 points. The word Mr. Sue, I've read certain documents produced by Mr. Sue. I'm so sorry. I've gone. We're 1:05. I'm so sorry, my lady.
No, just finish what it is you're saying.
The words effective hearing are not words that English people themselves use unless they are lawyers. Mr. Sue has a relatively imperfect command of English, so far as I understand it. He does speak it. He's not incomprehensible, but the use of effective hearing, it's not words I would naturally find within his normal register, from what I know of this gentleman. I think it's highly unlikely that he was thereby saying to the world, I'm going to lie at this hearing, therefore it will not be an effective hearing. But I can only say that there it is. He consented in the particular circumstances he was in to the adjournment of the first means hearing as it had been listed at that date.
Well, to me, it's sort of more likely to echo the basis upon which the application for the adjournment was made.
Well, I
I
haven't seen the actual underlying document, so I'm at some disadvantage, but my lady may well be right. But that's with the next date, which may be the moment to stop.
Okay. Do you want to give us the next date, or is this the moment to stop?
Well, I was just going to say the next date is he is released from Pentonville on the 9th of April.
Thank you.
And of course, he's then immediately subject to the first Waksman order, which means that he then has to go down to Charing Cross Police Station daily. And that's a pretty substantial trip from where he's living, I believe, in Maida Vale. And of course, for what it's worth, we are at the height of the pandemic at the time. And what I was then going to do, and it may be convenient to do at a later stage, is give the court, I think my lord was keen to hear this, some sort of picture of the circumstances in which he is living from the 9th of April, because he has been at liberty in the sense of not incarcerated in a prison between the 9th of April and last week. So there was a period of 15 months where he was within this jurisdiction and not in one of Her Majesty's prisons.
Is the best place for that the statement of the 14th of December?
Yes, exactly it. And for my lord's benefit, but I'm going to come to it, there is a witness statement that was put in by Mr. Sue for the purposes of the application that came before Mr. Justice Waksman in January 2021, dated, which my lady quite rightly says is dated the 14th of December, which sets out a variety of evidence, including his personal circumstances at that moment. But that may be an appropriate time to adjourn. I'm entirely, of course, in the court's hands.
Thank you very much indeed. Given the shortage of time now, we will actually return it to 2 rather than later.
Thank you.
And also, I think you'd be grateful if you would both agree how to divvy up the time this afternoon. I appreciate there's very little of it, but that is all there is.
No, quite.
Thank you very much.
Thank you, my lady.
All right.
figure